you have already pushed the class towards the large program. We shall see how we are going to handle it. Today, as an introductory part, we are going to put a sort of territorial demarcation. What type of relationship are we really speaking? We're trying to see employment law, and we said it regulates employer-employee relationship. But what type of relationship is that, really? Of course, at the end of the beginning of the class, we said it is a commitment to render service, especially from the side of the employee. But there could be other commitments to render service outside of that relationship. Therefore, in order to identify the relationship and to limit the scope of application of our law, there is a need to determine, to delineate the boundary so that we may not misapply the law for an intended result, for an intended type of relationship. Therefore, for this, two things. One is definition. We need to define the relationship. But definition may not be sufficient because sometimes definitions overlap. They try to define different relationships. They try to put on the same basket. Therefore, differentiation, distinction is also important. We need to distinguish or we need to differentiate between similar definitions. So step one, we'll define. But sometimes definition may put a lot of things in one package. Therefore, we need also to do a sort of compare and contrast. How is that different from that type of relationship? So in this area, as I tell you last class, there are three relationships that tend to overlap because there are similarities in the relationship. Therefore, sometimes they confuse. One is principal-agent relationship. The other is employer-employee relationship. The third one is client-contractor. Sometimes they call it independent contractor. I see. But client-independent contractor relationship. So these three relationships, they have similarities. They have also their own differentiation. As far as similarity is concerned, the agent is there to render service to the principal. The employee is there to render service to the employer. The contractor is there again to some extent to render service to the client. Therefore, the common denominator is there is a sort of service provision from one of the parties to the other. The second thing of similarity is mainly the source of relationship is contractual. There will be contractual relationship between the principal and the agent. There will be contractual relationship between employer and employee. There will also be contractual relationship between client and contractor. So because of this, sometimes there is a sense of confusion between these relationships. But that doesn't mean that they are the same. They have their own peculiar features. And our purpose basically is when we speak of employment law, the scope of application is limited to employer-employee relationship. Agent-principal relationship is outside of our ambit. Client-contractor relationship is again outside of our ambit of labor relation or employment relation. It is because of this that there is a need for territorial demarcation. Actually, it's not only for purpose of employment law that this distinction is relevant. Even for other branches of laws, to a certain extent, this distinction is relevant, especially employer-employee, client-contractor relationship. Sometimes agent-principal relationship is a little bit different, but especially these two, employer-employee, client-contractor relationship, differentiation is important for other branches of laws too. Where do you think, now that you are a fourth-year student, you have already studied many of the domestic branch of laws, where do you think, where do you think is this distinction relevant? In what branch of law is, yes, exactly. In tax law, if the relationship is employer-employee relationship, the employer is duty bound for payroll deduction. The income tax due from the employee needs to be deducted at payroll by the employer. Otherwise, the employer may be required to pay that amount. But if the relationship is client-contractor relationship, the contractor is going to declare his own tax either every month, if it is a VAT, or if it is a TOT, every 3 months. And at the end of the year, he is going to declare his income and pay by his own. If at all there is a duty, there may be withholding amount, 2% or 30%, may be withheld. This is a new duty actually included. It is not the final tax. For the employer-employee relationship, it is the final tax that needs to be deducted by the employer from at the payment, at the window of payment. But for independent contractor, is another arrangement. The final tax due from the contractor is to be paid by the contractor himself at the end of the year. The employee, the client, if at all there is a duty to deduct either 2% or maybe 30% of the payment. It's not a matter of assessing the tax and withholding. It is rather simply withholding a certain amount of the payment. That may not be the final tax. But when it comes to employer-employee, the final tax is to be collected by the employer. So one area where this distinction is relevant is in tax law. What else? In what other branch of law? There is a need to rewind your memory to your previous courses. What about the employer-employee relationship? Who retains the intellectual property? I'm not an expert in intellectual property. Extra-contractual liability. You remember? The concept of vicarious liability. In vicarious liability principle, if an employee incurs liability at the time and place of work, it's not 24 hours insurance. It is only when the liability is incurred as in discharge of obligation, you remember. And when a certain liability is incurred in discharge of obligation, if it is incurred at the place of work in time of work. If that is a liability, if the liability is incurred at this relevant time and place, the employer will be vicariously liable. Vicarious liability to me is not a matter of exonerating the employee. In addition to the liability of the employee, the employer will also be held vicariously liable to the victim. But if the relationship is client-contractor relationship, the contractor is to discharge his obligation at his own risk. The employer cannot be held, the client cannot be held liable for the actions of the contractor, for the omissions of the contractor. Therefore, for tax law, that distinction is relevant. For law of extra-contractual liability, that distinction is relevant. I don't know, for purpose of intellectual property, to some extent, there may be relevance in that distinction. But for our purpose, let's ignore the other importance of this distinction for purpose of employment law. The relationship is very much relevant. Under the civil code, these three relationships are regulated in different sections of the civil code. Therefore, the law recognizes their distinction, their difference. Had they been the same, they would have been incorporated in a similar arrangement, similar structure, but that is not the case. Agent principal. The definition, you will find it under 2199 of the Civil Code. So, agency. Agent. What does it say? Agency is a contract whereby a person to me, the agent, Have you studied the law of agency? The principal, to represent him, who is the him? And to perform on his behalf one or several legally binding acts So agency is a contract whereby a person, the agent, agrees with another, the another is the principal. To represent him, the him is the principal, and to perform on his behalf, on behalf of the principal, one or several legally binding acts. So basically, service provision representation. Basically, it is an issue of representation. There is an element of service provision, but that service provision mainly is representation, representing the principal, and therefore entering into a sort of a juridical act, legally binding act. Employee. So this is 2199 Civil Code. Employee 2512. A contract of employment is a contract where a contract of employment is a contract whereby the employee undertakes to render to the other party, the employer, under the latter's direction, under the employer's direction, for a determined or undetermined time, for a definite or indefinite time, services. So, undertakes to render service. You have the service provision element in the definition. Services of a physical or intellectual nature, in consideration of which the employer undertakes to pay him, to pay to the employee. So this is how the Civil Code defines employer, a contract of employment. Then contractor, the relationship. 2610. The three definitions formulated by the Civil Code. Almost similar formulation, we will find it in the current labor proclamation as regards to contract of employment. But at the time of the Civil Code, this is what we had. What we have had. So now, in almost all cases, there is a service provision under contractor. Of course, it may not only service, because he undertakes to produce a given result. Implicit in it, with the service provision, there may be a material outcome that comes out at the end of the day. A given result is expected from the contractor. But even in that case also, there is a service provision in it that the contractor is expected to do. Now, you have here a sort of representation representing the principal and entering a sort of legally binding acts. And at the end of the day, it will be the principal, so long as the agent works within the scope of the authority, it will be the principal that will be held responsible. Even the agent will be exonerated from any liability, so long as she or he acted within the scope of the authority. But if you try to see the definitional elements, under employer-employee relationship and under contractor-client relationship, you have element of consideration. In consideration of remuneration, in consideration of wages. So a certain element of payment is involved in the definitional element, either in employer-employee relationship or in client-contractor relationship. Payment is not a definitional element of agent-principal relationship. You don't find it in the definitional formulation. Therefore, a possibility is it could be even for free. Agent-principal relationship could be a pro bono service, a service without remuneration. But in this case, it is an essential element of the definition. That is one thing you need to see. This makes contractor-client relationship similar with employer-employee relationship, the element of consideration. But terminologically, of course, contractor is expecting remuneration, employee is expecting wage. Technically, there is a difference between the two. We'll try to see that. But from this perspective, they tend to be similar. But the employer is to render service, the employee is to render service under the employer's direction, whereas the contractor is to produce a given result under his own responsibility. The direction element. The contractor is more liberated than the employee. The employee is under the direction of the employer, whereas the contractor is to render the service or to produce a given result under his own business risk as an independent contractor. That is the reason why the issue of vicarious liability is not involved, because he is to render the service at his own business risk. Then, from even though Article 2199 is defining agent-principal relationship from the angle of a contract, if you go to other provision of the Civil Code, 2189, I think, you will find another story. Everything cannot be explained in one provision. To have the full picture, you need to see the different provisions in that chapter. So 2179, thank you. not 2189, 2179. The authority to act on behalf of another, to be an agent, that means. The authority to act on behalf of another may derive from law or a contract. Even though 2199 states that agent-principal relationship emanates from a contract, it is part of the truth. It's not the whole truth. Because when you go to 2179, it tries to convey a message that agent-principal relationship may emanate from law other than a contract. Therefore, agent could be a status rather than a contract. But employer-employee relationship is a contract. Client-contractor relationship is also a contract as well. But agent-principal relationship could be a status because it can emanate from law. So, source of authority, source of the relationship, let's call it. Sometimes it may not be an authority. The source of the relationship for agent principal could be contract or law, whereas the source of authority for employer-employee is a contract, the same thing to client-individual relationship. Therefore, being an agent could be a status. A status to me, like what we call slavery is a status. You will find yourself in that position without your consent. Tenancy was a status, but because the tenant finds himself as a tenant. But when it comes to a contract, employee is a status because you will enter into a contract willingly. It's not a status. That is the difference between status and contract, actually, from this perspective. Therefore, you have that. Could you think of a situation where being an agent emanates from law, from your previous courses? What do you think? How do you, yes. That is the area where it emanates from law, in family law. I think one of the provisions of our family law, the parents of a minor child shall be guardians and or tutors of their minor children, so long as the marriage exists. If one of the parties is separated for different reasons, the other party may assume that responsibility. So the guardian is there to take care of the minor child in bringing up, to administer the property of a minor, and to enter into a legally binding acts as regards to education or as regards to property administration. Therefore, this is one of the areas where being an agent becomes a status.
11:14 a.m.
Comes from the operation of the law. And this is one of the areas where the service is a pro bono service. You don't expect, the parents do not expect remuneration for this service. In fact, one of the provisions of the family code says the service is for free unless blah blah blah. If that phrase after the unless satisfied, there may be a payment, but in principle, it is a pro bono service. So, this is where the distinction comes. In this case, you don't expect an employee to be a status, it's a contract. You don't expect a contractor to be a status because they purely emanate from a contract. That is, you voluntarily, of course, the voluntariness is quote unquote because there may be a pressure, an economic pressure that may force you to consent, but at least formally there is a formal consent. But in that case, that will not be the case. So, if we are going to put a sort of chart for distinction purpose, of source of relationship, for agent-principal relationship, it could be law or contract. Employer-employee relationship, contract. Client-contractor relationship, contract. In terms of remuneration, agent remuneration is non-essential because it may be a pro bono service. But in employer-employee relationship, it is an essential element, part of the definitional element, because it is for in return for wages that the employee renders service. In client-contractor relationship, it is essential because remuneration is there in the form of the code calls it price rather than wage. Price of service, price of the product. In terms of identity, identity to me, can an agent be both physical and legal person. Can an employee be both physical and legal person? Can a contractor be both physical and legal person? What do you think? Could you think of an agent as a legal person? Or being physical person is indisputable. Technically, they can be physical persons because it is a service provision commitment. So service needs to be rendered, but could there be a possibility that an agent would be a legal person?
Yes.
Identity, it could be both physical to be natural, this could be natural, or biological. Natural or legal person. An agent could be, you may give a power of agency either to a natural person or to a corporate entity, especially in modern world, so that's natural. For example, if you brought a certain property, an automobile from abroad, you may give a power of attorney to a certain transporter to bring that automobile from Djibouti to Addis on your behalf. You may not delegate it, you may not, because there are transitors as a legal person, they will assign their own employee, but you as a principal, you will delegate this power to that enterprise, to that transitor as a legal person. Therefore, it could be possible. What about an employee? Can we think of an employee as a legal person?
I don't think so. I think, of course.
Yeah. When we speak of an employee, we are speaking of a natural person. If you look for someone to render service, to bring in employees and render service, that relationship is not employer-employee relationship. It is rather the agent that brings in the employees will be an independent contractor for you. The whole history, the whole issue of exploitation, issue of safety, issue of maternity leave, annual leave, limitation of working hours, sick leave, whatever, they all try to take into account a natural person as an employee. Otherwise, this all minimum labor condition or whatever will be meaningless anyway. Therefore, the human dignity, the human nature is involved in employee-employer relationship. Of course, many companies abroad are trying to do a lot of things through robots, but that's not employer-employee relationship anyway. Maybe the robot operator at the end of the button will be an employee. But the other aspect, of course, it may have an effect of displacing labor, but that relationship with robot is not an employer-employee relationship. So we are speaking of a natural person in this case. Actually, under the proclamation 68 of 75, at the time of the DERG, the definition was very much clear. Physical person in Amharic, in English, but in Amharic actually it's clear when you try to see the definition. ግለሰብ ነው ሰው ነው አይደለም የሚለው ግለሰብ ነው የሚለውና the Amharic version in this respect is clear enough. Of course, the English version says a person, but the ግለሰብ is not technically a person when we speak when we become to the true meaning is a physical person, excluding legal persons. Contractor, you have a lot of contractors actually when you try to see the construction industry, like in many cases, the term contractor mainly applies to this type of relationship. That you enter into a certain real estate company to come up with a dwelling house at the end of the day. That could be a physical or a legal person, natural or legal. Into the relationship. Termination. Agent-principal relationship is termination at will. Meaning the principal can terminate the relationship at pleasure. If you try to see 22-26, revocation of agency. The principal may revoke the agency at his discretion and where appropriate, compel the agent to restore to him the written instrument evidencing his authority. Any provision to the contrary shall be of no effect. So, revocation at will. The relationship could be revoked. From the other side, there is no problem because if you deny the agent to revoke, it will be forced labor. If you deny the employee to revoke, it will again be forced labor because this is provision of service, we say. If you deny the contractor, again it will be. But from the other angle, they are also at liberty to terminate. The principal is at liberty. What about the employee? What is the employer? Is it at will or yes? We are dealing with the civil code. Even at the time of the civil code, if you try to see the termination under the civil code, termination by law, Article 2573 of the civil code. Compensation for dismissal. The employee shall be entitled to fair compensation where the employer terminates a contract or refuses to renew it without good cause, justifying fully his decision. Therefore, what it means is, if the employer terminates a contract of employment or refuses to renew a contract of employment without good cause, he will be required to pay compensation. He may not be required to reinstate the employee, but he will still be required to pay compensation. Therefore, it's not at liberty. The employer is not at liberty to terminate. even under the civil code, because we are taking the definitional element. So whether the reason for termination is justified or not, it will be reviewed by a judge. If the employee takes the case to the court, it will not be a mere discretion and decision of the employer to terminate. The judge will take the facts and the law and determine whether there is justified cause or not. If justified cause, no problem. But if it's not justified cause, it will be, the employer will be required to pay compensation. So the termination is not at will. When it comes to employee client-contractor relationship, you have 2631. Unilateral termination of a contract. The client may at any time terminate the contract. The contractor shall in this case be entitled to the price that had been fixed. So termination, again here, it is at will. Unilateral termination is possible. Therefore, this is a sort of similarity between agent-principal relationship on the one hand and client-contractor relationship on the other hand. So there are similarities and differences in these relationships. Especially, there is a closer relationship between employer-employee on the one hand, client-contractor relationship on the other hand. Here is actually the confusion lies, differentiating whether a particular relationship is employer-employee relationship or client-contractor relationship, because the source is both a contract. In both cases, there is an element of payment, except that in this case it could be natural legal. There are few, in this case, in source of relationship differs. The payment aspect also differs. Natural legal person also differs. Relationship at will is also a difference. Therefore, there are a lot of differences between agent-principal, employer-employee relationship. But when you come to this territory, there are some common features. And it is because of that common feature that the confusion arises. So, because of that, in many countries, courts try to create further elements of distinction between these two things. In order to distinguish employer-employee relationship on the one hand, and client-contractor relationship on the other hand, there are further indicators. Of course, no one indicator is conclusive, but they are helpful. Indicators. Some of the indicators emanate from the very definition. You remember when we spelled out the definition, employer-employee relationship under the employer's direction. the employee is to render service under the employer's direction. But in client-contractor relationship, under his own responsibility, the contractor is to render service under his own responsibility. So as such, there is no closer power of control from the side of the client over the activities of the contractor. Therefore, from this definitional distinction, we have what we call command and control test. To what extent is the other party having a power to command? To what extent is the other party having a power to control? The higher the power of command over the other party, it is likely that the relationship is employer-employee relationship than otherwise, than client-contractor relationship. The higher the degree of control, it is highly likely that the relationship is employer-employee relationship rather than otherwise. Because in that case, the degree of control is low. What does that mean? What elements does this command and control test involve? Power of instruction. The power to instruct. Under the latter's direction means there is a power to give instruction. This instruction may involve what to do, where to do, how to do it, maybe with whom to do it, if it is at work. When to do it. So, implicit in power of directing is this. The employer is there to instruct the employee what to do, where to do, place of work, nature of work, modality. The process is also quite important. The time is also place of work, time of work, and with whom to do it. Work arrangement. If it is a sort of assembly line, you may be assigned with colleague to undertake it. So these all are within power of instruction. The power to instruct. Then the control test, the power to monitor. Supervision. that his instruction or its instruction is complied with. Monitoring. Is it being done in accordance with the process, quality, time, and of course, place. So the command and control test tries to show us the power of instruction, the power of monitoring, and if for whatever crazy reason something went wrong from the side of the employee because of the fact that he failed to comply with any of this, either he failed to deliver on time, he failed to deliver a qualitative product, he failed to work in team, etc. The power to discipline, the power of disciplining. So taking appropriate action for non-compliance of the instruction. Non-compliance towards the instruction, appropriate action may follow. That action, disciplining, may involve many steps. It could be oral reprimand, written reprimand, first written reprimand, second, third, whatever. It goes to the extent of dismissal. So it could range from according oral reprimand to terminating dismissal. This all involved in power of discipline. Therefore, if one of the parties in that particular relationship has these all powers, it is highly likely that the relationship is employer-employee relationship than client-independent contractor relationship. Especially in client-contractor relationship, the client is interested on the given result. You remember under the definitional element, 2610, undertakes to produce a given result. The client is interested on the result rather than on how the result was achieved, where the result was made, etc. Usually when I try to give an example to my students in this connection, the relationship with your domestic servant. Employer. There is one type of relationship in a household together. Another relationship would be your relationship with a tailor. For example, you would like, at the time of graduation, you may decide to have a new suit. So you may go to Mercato and require someone to make that dress for you. So you will enter into a sort of contract. Either you will take a certain meter of clothes from your own, or you can even purchase, and you may require the individual to make the suit for you. Are these two relationships similar? Your relationship with your domestic servant or your relationship with someone in Mercato to make a suit for you? You say this is suit. Yes. You see, in this case, in the case of the Mercato individual, so long as the quality is maintained, so long as the delivery is timely, you are not interested in the details of the process. You may enter into a contract in Mercato, but he may decide to go to Saris and make it over there. You are not interested in the place of work. He may sleep during the daytime and he may decide to do it on the night. You are not interested in the time also. Your interest is on the attainment of the given result, quality and time. So long as the quality is maintained, even he may assign or subcontract another individual to do it for him by making arrangement as to how it cuts. It's simply to move through that process. Another individual could undertake that. You may not as such require the personal performance, so long as the quality and the time of delivery are maintained. These are very important for you as far as a client is concerned. But when it comes to the household level, the degree of control, the degree of command is very strong. Therefore, in that case, your relationship is more of employer-employee relationship in the domestic servant case, and independent contractor-client relationship in the other hypothetical case aspect. So there is an element of professionalism in this case that you may not have the knowledge to control. So one indicator, additional indicator to this is the higher the professional service, the higher the professionality of the service, the highly likelihood of the relationship being client-independent contractor, client contractor, rather than otherwise, rather than employer-employee. So, a professional is more independent than a non-professional, skilled, semi-skilled, or manual worker. Therefore, if the service becomes complicated, your degree of command, your degree of control will be diminished. Therefore, it is highly likely that the relationship is someone working at his own responsibility rather than under your direction, because the direction element will diminish in that relationship. The other indicator, some literatures call it economic reality test. they will try to see the economic reality of the parties. And if both parties are comparable in terms of economic status, it is highly likely that the relationship is independent contractor relationship rather than otherwise. But if the factual case tries to show you that one of the parties is economically dependent on the other, it is highly likely that the relationship is employer-employee relationship than client independent contractor relationship. Another indicator, of course, no one indicator is conclusive. These are simply signs when we are confused as judge or as a lawyer to determine, we are going to take a lot of factual situations to arrive at a meaningful conclusion. Otherwise, one of them is dominant. That is something you need to underline. Possibility of having multiple parties at a time. Is the party attached to a single client, or is there a possibility to have multiple clients at a time? If it is employer-employee relationship, since 8 hours per day is a regular working hour, since substantial part of the day is to be attached to the benefit of one party, you will not have the luxury of having multiple claims, multiple parties to engage with you. If your relationship is independent contractor relationship, you will have multiple parties. For example, lawyer. If you are a lawyer, you can have a lot of clients. You may have a lot of files. But if you are a negrefetch in a company, you are only having a single client, your employer. In both cases, the service is provision of legal service. But the provision of legal service of a lawyer is different from a legal service of another affairs. Of course, in English, both of them we call them lawyer, but in Amharic, we have, Amharic is much more flexible. About and benefit. What is the difference? Have you noticed the difference between the two? What's the difference? Benefit is an employee, whereas the tabaqa is an independent contractor. The negrefetch is having only one client at a time, but the tabaqa may have hundreds of clients at a time. So the relationship the company has is different between the two. The tabaqa is under his own responsibility. It's not an employee of the company. The company is at liberty to terminate because it is client-independent contractor relationship. Whereas in this case, the negrefetch will have sort of protection of the law prior to separation. So this is again another indicator. Who provides working tools and materials? Provision of tools and materials. Working tools and materials. Actually, this indicator is somehow actually explained in the code. If you try to compare the Civil Code provisions 2530 of the Civil Code tools and materials supply. Unless the contrary is agreed or customary, the employer shall provide the employee with the tools and materials necessary for his work. If there is no contrary agreement, the duty to provide tools and working tools and raw materials is the duty of the employer. The employee is expected to come empty-handed, to mentally and physically fit to render service. But if you try to see client-contractor relationship, that is the reverse. 2630. Materials and tools. The contractor shall provide at his own expense the materials and tools necessary for the carrying out of the task. It may, however, be stipulated that he shall only provide his services and that the material or the tools shall be provided by the client. So, it is exactly the reverse. Unless agreed, the assumption of the law is the employer will provide tools and materials to the employee. When you come to client-contractor relationship, unless otherwise agreed, the assumption of the law is that it should be the contractor who should provide the material and the working tools. Of course, otherwise agreement is possible for the law doesn't have any objection for otherwise agreement, but in default of any agreement, for employer-employee relationship, employer is duty bound to provide tools and materials. For contractor-client relationship, the contractor is expected to provide working tools and materials. Therefore, in a relationship, when you are confused, one of the areas that we take into account is that who provides tools in this relationship? Who provides raw materials? Was it the duty of the so-called client to provide tools? If the client was, the assumption was, if he was to provide the tools and materials, that means he is trying to assume the duty of an employer. If the other party was providing his own, the assumption is he was an independent contractor. So this is again another indicator. If you are confused to determine the relationship, you will again take this into account by looking at their written contract, or even if they have no written contract, by calling on witnesses on how the relationship was being operated, you may get a certain clue as to the nature of the relationship. Engagement, duration of engagement. May also be helpful in identifying the relationship. The longer the engagement of the parties, the highly likely that the relationship is employer-employee relationship than client-independent contractor relationship. In many cases, it's not in all cases actually, in many cases, client-independent contractor terminates briefly. Like your Mercato customer, once that you take your suit, you may not have any further relationship. That relationship could be no longer than 1 month. But your relationship with your domestic servant, it may go for years. So, the duration of the engagement of the parties could also be something. In employer-employee relationship, there is an element of continuity of relationship, longer duration of relationship. Whereas in professional services, usually the relationships are, comparatively speaking, shorter and brief. So, how long do the parties remain engaged in this relationship? Could also be another indicator to determine the nature of the relationship. Mode of payment. May also serve as an indicator. Mode of payment to me is it daily payment, monthly payment, periodical payment versus piece rate? Piece rate. What is the difference between periodical payment and piece rate? Periodical payment is a payment depending upon time interval. You will take into account the time into account. If it is day, it will be daily. If it is monthly, or if it is bi-weekly, so long as that time arrives, payment will be due. You will be expected to pay, irrespective of the outcome. Piece rate is a sort of an outcome-based, result-oriented. It's not time-oriented. It is rather result-oriented mode of payment. For example, in the case of tailors, ልብስ ሰፊዎች, usually is piece rate. Shoemakers in shoe factories or in garment factories, predominantly they would like to attach it to a sort of piece rate mode of payment. ጥንድ ጫማ ሰርተህ ከዋልክ 30 ብር፣ ሁለት ጥንድ ከሆነ 60 ብር፣ ስትገላጀጅ ውለህ አንድ ጫማ ብቻ ከሰፋ 15 ብር ነጠላ ከሆነ ማለት ነው። Therefore, the mode of payment will supervise you by itself. Therefore, in piece rate type of payment, the control test is very low because the nature of the job, the nature of the payment, will somehow control the behavior of the employee. But if it is a payment of payment, as an employer, you will be interested on controlling so that the period will be a productive period to you. Therefore, from this perspective, if the mode of payment is periodical, it is highly likely that the relationship is employer-employee relationship than client-contractor relationship. So again, another, you will take into account the mode of payment. Of course, who pays tax also in their contractual arrangement? If the tax is earlier, we have already indicated in that. If the tax is to be deducted from the remuneration to be paid to the employee at payroll, it is highly likely that the intention of the parties will be taken into account anyway. So their intention is to be manifested in their contractual relationship. So if they somehow in their contractual relationship, they put that the tax will be, a gross payment will be given to the employee and tax will be deducted in accordance with the employment schedule income tax, then it is highly likely that the relationship, the intention of the parties was to treat each other as employer and employee than independent contractor-client relationship. This could also be another indicator. But finally, however, is what we call the dominant impression test. The dominant impression test, as I said, these are simply signs, symptoms that help to assist us in determining the relationship. No one indicator is conclusive. Therefore, by taking all this, what is the dominant impression? Does the total sum up of these aggregated indicators tend to show you that this relationship is client-contractor or otherwise? Therefore, it will be a sort of subjective appreciation of the different variables. If the total sum up of this relationship tends to show you that the relationship is employer-employee relationship, you will fall as that. If by looking at these all indicators tend to show you that the relationship is more of independent contractor-client relationship, then you will vote otherwise. Therefore, your holding will be decisive. If you hold that the relationship is employer-employee relationship, then you will apply the labor proclamation to regulate their relationship. If your holding is otherwise, then the labor law will no longer be applicable. Therefore, their relationship will be regulated outside of the ambit of the labor proclamation. So the whole exercise for this is to determine the scope of applicability of the regulatory framework. Okay? ወደ ምሳ የተጠጋ ሰዓት ትንሽ ያስቸግራል። So I think these are what we need to consider as introductory framework. Then with this, we are going to move to the operational part of the labor proclamation. Up to now, we are trying to see introductory remarks up to the development and as to differentiation of the relationship. Especially our today's exercise was helpful in understanding the nature of the relationship. So with this, for next class, you will be expected to bring the labor proclamation with you. Otherwise, it will this will require you to come up with your own copy out of pocket expense management. Otherwise, it will be difficult to follow because we are going to put the provisions on the assumption that everybody has a provision. We are going to discuss on that basis. You may find it in, if you Google, you may find it in soft copy. I don't know to what extent you will have that access. Otherwise, that is not my responsibility. Okay? Okay, anything?